Hello, everybody.
Good morning. Can I have your name, please?
Gary Thomas.
Okay, thank you. I will be with you in just a moment.
Gary Thomas.
Yep.
You know, you got a bench warrant out of the 34th District in Romulus?
Yep.
Okay.
They're not gonna come get me.
Okay. I just figured I would let you know in case you were unaware.
Yeah, they've been saying that for the last 4 years.
Okay, yeah. You don't have to say anything else. I just wanted to inform you.
Okay. Now calling case numbers 22S00157 and 24S00209. These are the State of Michigan versus Gary Rashad Thomas. Appearances for the record, please.
Assistant Public Defender Sonia Chanot on behalf of Mr. Thomas. Mr. Thomas, state your full name for the record.
Gary Thomas.
Thank you.
Thank you. So today is the date and time set for an arraignment in the matter ending in 209. The matter ending in 157 is just set for a show cause hearing. That means basically that you just owe money on that one. So with this case ending in 209 today, as I said, is the date and time set for an arraignment in this matter. What I have is a misdemeanor complaint that charges that on or about April 20th of 2024 at Road, you did knowingly or intentionally commit the following act or acts that under the circumstances posed an unreasonable risk of harm or physical injury to a child by leaving a child 10 and under in a public place while intoxicated and abandoning them to get on a city transit vehicle. This count is otherwise known as fourth-degree child abuse. Do you understand that charge?
I guess I do now.
Okay, and I'm sorry, I didn't catch quite what you said.
I said, I guess I understand now.
Okay, thank you. So that is a misdemeanor with a maximum penalty of up to 1 year in jail or probation for up to 5 years. Do you understand that potential penalty? I do
Yep.
need you to say it out loud. Thank you. Okay. Count 2 charges that at the same date, time, and location, again, you did knowingly or intentionally commit the following act or acts that under the circumstances posed an unreasonable risk of harm or physical injury to a child by leaving a child 10 and under in a public place while intoxicated and abandoning them to get on a city transit vehicle. So that is count 2. That is also fourth-degree child abuse. And again, that is a misdemeanor with a maximum penalty of up to 1 year in jail or probation for up to 5 years. So you understand that there are 2 counts against you.
So it's 2 counts of fourth-degree child abuse, the same shit? Excuse my language, I'm sorry.
Please be careful with the language you are in court. And yes, presumably 1 for each child.
Okay.
Okay. Okay. So did you have a chance to review an advice of rights form?
Yeah.
Okay. Do you have any questions about your rights?
Nope.
Okay. Attorney Chanel, do you wish to address the plea and the bond?
You said the plea and the bond?
Yes.
I'm prepared to address the bond.
Okay. Presumably he's standing mute to the charge.
Yes, Your Honor, we stand muted to the charges in regarding bond. My client is 33 years old. He is gainfully employed at Five Guys Restaurant. He is currently on probation and he is attending drug court in front of Judge Kunke. He also expressed that he is awaiting to attend an inpatient alcohol treatment program. I did explain the bond conditions to him. I do believe he will comply going forward. And my client did express that he will appear for subsequent court hearings. Therefore, we are asking for a personal bond. Thank you.
Okay. Attorney Chanel, do you know if the children reside with your client?
I do not. Do they live with you, Mr. Thomas?
No, they live with my girlfriend.
At this time, the court will set your pretrial for July 25th, 2024. That will be at 9 a.m. over Zoom before Judge Washington. And the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are to report to community corrections within 24 hours of your release for drug and alcohol testing. Prior to your release, you are to be fitted with a scram tether. You are not to have contact with the minor children at this point. When the court says no contact, the court means no in-person contact, no contact through the mail, no contact over the phone, via phone calls, text messages, emails, social media, the internet in any way, shape, or form, or through third parties. You are not to leave the state of Michigan without the court's permission. You are not to engage in any sort of criminal activity whatsoever. And you are to appear for any and all dates set for you by the court. So that includes your pretrial in this matter on July 25th at 9 a.m. over Zoom. It also includes going to community corrections within 24 hours of your release. You appear to have been muted. I did send a prompt asking the jail to unmute you. Thank you. Okay. And I should note that you are also not to go to the children's place of residence. Do you have any questions about any of these conditions?
Nope.
Okay. They will be entered into the law enforcement information network, so they'll be readily available to any police officers that you may come into contact with. And if they have probable cause to believe that you have violated one of these conditions, then they can arrest you on the spot. And you'll be held for a bond violation hearing in front of the judge, who may revoke your bond and set a new, more restrictive one. At this time, the court will set a personal recognizance bond in this matter. Attorney Chenault, do you have anything else?
Nothing further. Thank you.
Okay, thank you. And sir, if you don't have any questions for the court at this time, then you are free to stand up and tell the jail that you are finished.
And what a shocker. I went to the next date where he was supposed to have his hearing, and he was a no-show.
Also have Crystal Ramirez here.
Okay. On the record in state of Michigan versus Crystal Ray Ramirez, 2400857SN.
Matt Nagel for the people. Jacob Raleigh on behalf of Ms. Ramirez.
And you are Crystal Ramirez? Yes, ma'am. Thank you. Today's the date for final pretrial. What's our status?
I do have a victim present today, Your Honor. The victim also informed me that apparently Ms. Ramirez and the victim used the same nail tech. And according to the nail tech, Ms. Ramirez had passed a message through the nail tech to the victim, telling the victim not to appear today, but the victim did appear today.
Well, that would be an alleged violation of bond. If you would like, you could file a bond violation on that. But in the meantime, Mr. Raleigh, are you wanting to, I don't know if there's been plea negotiations today, or if you're wanting to just leave this on for jury in 2 weeks?
At this point, yes, we'll leave it on for jury in 2 weeks.
Okay. Ms. Ramirez. Yeah. Don't mess around with your bond. Bond is a matter of trust, right? So you get to be out in the community, and I trust that you're going to follow the rules. So continue to follow the rules so that we can get through this trial. I'll see you back here June 24/8. I'm not asking for you to respond. I don't want to hear it. I don't want to hear excuses. I don't want to hear denials. I'm just giving you a warning right now so that you can continue to be on bond for 2 more weeks. No official bond violation has been filed. So this is just a warning, just to remember to mind your P's and Q's so that we can get to trial. Trial is June 24/8. Do you need a new trial notice, or you have yours?
You have notice of your court date, 2 weeks.
Sir,
We're okay.
Sir, no.
I don't-
No.
It's not appropriate. You won't be allowed to be in the courtroom if you can't sit and just be quiet and watch. So you can sit and be quiet and watch, or you can step out to the hallway. That's how this works. Okay. You said you have your court notice? Okay, remember to follow your bond conditions. I'll see you in 2 weeks. You're all set.
She started crying, and all of a sudden you hear, let me get my, and I think he said either girl or woman. And they were like, nope, shutting that down. Be safe, be well, sleep sweet, and much love.